Hello, chat. Hold on one second here. All right, chat. Anyways, welcome to the show, guys. Deviation off the Brendan Banfield stuff because this was all up in the air up until this afternoon. And let me tell you some good news for Aaron Spencer. That's the TLDR. But we're going to go through what's happened. If you guys want to see Access, what's this show? I'm starting early. Yeah. We got a lot to do tonight and go through all this. And I want to go through all of it at a reasonable time because we got some work to do. We got some work to do with some guys. We got some work to do. We got some work to do with them. So we got to work on them. But I need some time to do it. But we are going to get started on this Aaron Spencer stuff. Good evening, everybody. Guys, if you don't know me, my name's Sean, someone's potentially criminal. I'm an attorney in the Cleveland area, and we're going to go through what's going on, really the biggest stuff in the Aaron Spencer trial saga. We're not going through all of it because there's a bunch of shit that went down, but we're going to go through the big stuff. We're going to go through the big stuff here. And yeah, I mean, like I said, the TLDR is that Aaron Spencer and the defense team already got a monster kill. So let's start with this. So what happened? And remember, Aaron Spencer is the Arkansas man who his daughter was the victim of a sexual assault at the hands of Michael Fosler, who was a schmedophile and pedophile. And, he was a map, and maps get the wall. That's what they get. Well, anyway, Fosler was accused of molesting and abusing Aaron Spencer's daughter, his 14-year-old daughter. After Fosler was charged, he was told stay away. And then one night, Aaron Spencer went to his daughter's room and found out she was gone and missing. Aaron Spencer started driving through the area and caught Fosler in a car with his daughter. Aaron Spencer, and these are all facts the prosecution has stated, chat. We went through this already. Spencer chased them. Fosler refused to stop until Aaron Spencer ran them off the road. Then Aaron Spencer pulled out a handgun of some sort and put 15 rounds into Michael Fosler and then proceeded to beat on him a little bit, which, you know what, at that point, based. It's like Gordon Ramsay cooking a steak. Based. That's what happened. And they still charge him with murder. This is also the trial and court case where the judge on this, Barbara Elmore, had put out a gag order that was so restrictive, even the Arkansas Supreme Court was like, we ain't doing this. It was so restricted that nobody in Aaron Spencer's family could talk. No one could talk about the case at all. That's why we never heard about the case till things got lifted. So, Spudgut says he missed with one round. You know what? Remember, Ted Williams, at the height of his career, was batting, bat like 404. That means 60% of the time he wasn't getting hits. So it happens. You can't be 100%. Can't be 100%. Gary would have been proud. Oh yeah. Gary Plache is looking down on him saying, "Why, Aaron? Why?" Yes, she is the same judge who was handling his case. The pedos case. Kia Paddock said nobody could talk about it, not even a fat Ohio attorney. Well, I didn't know it existed until the gag order got lifted. I didn't know this case existed until the gag order was lifted. Now, from here, there are some updates, and we're going to start off with about roughly on the 13th, so about 10 days ago. And the state started off with this. The state amended their information. Remember, they didn't go in front of a grand jury for this, but apparently in Arkansas, they do informations for these. This didn't go in front of a grand jury. And think about it. If this had gone in front of a grand jury, they probably would have no-billed. But Arkansas is one of the many states where you don't need a grand jury to charge someone with a felony. Once again, that's why I love the state of Ohio. Under our state constitution, Aaron Spencer cannot be charged unless a grand jury agreed to charge him. But here, they can. So what happened? January 13th, we're looking at it, guys. What did they do here? David says, I don't understand charging by information. I do understand charging by information. I think it's unconstitutional. You can get charged by information in Ohio. You have to consent to it, though, because we don't let prosecutors end run around the law. And if they can't get the grand jury to indict, that's a sign they shouldn't charge. Yes, Ohio told information to fuck off. Now, from here, what did they charge him with? What's the amended information? They amended it. So what did they do? Well, they are charging him now with murder 2 as a Class A felony. And then they're also doing felony with a firearm. So they're doing what's called like a firearm specification or a firearm enhancement. So what did he do? Well, apparently he did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life. Well, to Michael Fosler's human life. Although I would argue that Aaron Spencer terminated that motherfucker with extreme prejudice and put in that work. Remember, we can't make God do all the work. We can't make God do all the work, chat. So what did he do? He killed Michael Fosler, and that was against a piece of dignity of the state of Arkansas. Remember, it's Arkansas, not your Kansas or their Kansas. Our Kansas. So now they have the enhancement. Well, because why? Well, he employed a firearm of any character as a means of committing or escaping from the felony. He could be subjected to an additional period of confinement of not to exceeding 15 years, which that's pretty stiff. That's pretty stiff. That's pretty stiff. But that's what he's facing. That's what he's facing here. That's what they did to this guy. We're going to rack it up. Signed Chuck Graham, the prosecuting attorney, the biggest cuck in the county. We got to prosecute this for some reason. All right. Like, okay, it's not a surprise. That's pretty reasonable. You use a gun to commit a crime. The prosecutor thinks you did it. They're going to charge you with a firearm spec or a firearm enhancement. Fair enough. But the next thing that happened, this is where it gets weird, chat. This is where it gets weird. So this is filed that same day on the 13th. And this is where you're like, what is going on in this county? So January 13th. It is an order limiting courtroom occupancy and no recordings. So on the court's own motion, remember, sua sponte, of its own accord, and the interest of maintaining courtroom security, decorum, and the order of administration of justice, it's hereby ordered that until jury selection is over, news media and the general public will be limited to 20 individuals in the courtroom. Now that part, I kind of get. You're going to need all the jurors in one spot. But it says, with the 20 individuals in the courtroom will be crowded and some jurors will have to be placed elsewhere. This 20 does not include family or counsel and counsel staff, which, okay, at least that part's right. All news media must bring their credentials. Okay, yeah. At all times, the media shall wear a provided tag indicating they're a visitor or media. Okay, this one's okay. This one, I still don't have a problem with. After the jury is seated for trial, there will be more sitting spaces. Therefore, the court shall allow more individuals in the courtroom. Attendance shall be limited to total approximately 55 individuals total, including parties, counsel staff, family members, and the media and observers. Media access, one person per station newspaper at all times. That's fair enough. First come, first serve seating, all non-essential people will be available on a first come, first served basis. Okay. But this one right here, like, there's going to be a lot of people involved. So this 55 is going to be like how many after a while? Nothing. No seat reservation. I like that idea. You know, family members and all them, they can do things here that they can reserve seats. Okay, fine, fair enough. I'm okay with that. There shall be no recording devices in the courtroom at any time. Absolute horseshit. No cameras, cell phones, Apples, iPads, anything like that. Okay. Anyone may carry in a writing, pen and paper. Fuck you, Judge. Nothing stops the media from setting up cameras in the parking lot across from the courthouse. Yeah, nope. Nope. And the court finds this order constitutes a reasonable, narrowly tailored regulation of access that fully preserves the defendant's Sixth Amendment right to a public trial. No, it doesn't. Everybody should see what he did and how he dirt-napped some scumbag pedophile while safeguarding the integrity and orderly conduct of the proceeding. Yeah, because doing it out of public sight really enhances the integrity of it, honey. And once again, the great jurist Barbara Elmore. So yeah, you're like, who the fuck is this bitch? Who the fuck is this bitch? Yeah, she learned from Judge Gull. Learn from Judge Gull. Okay. You're like, all right, now you're just doing shit on your own. I'm like, I don't like that. Like, what are we doing here? Well, we skip a little further ahead, and Aaron and his team fire a shot across the fucking bow. Like, there's no turning back once you do this. This is crossing the Rubicon. January 16th, a motion for judicial recusal. This is it. Once you do this, you are locked in, chat. You are locked in. So, you're taking a shot at the king. You better not miss. So, what do they want to do here? Well, they're pointing out that the cumulative record of these proceedings results in questions about the impartiality. Yes. This case arises from the killing of Michael Fosler, who eludes Spencer's minor daughter from her home, while facing dozens of felony charges against her. Fosler was free on bond, which came from this court. But once again, as I told Nick Starro, getting your bond issued, having those charges and being out on bond is not unreasonable. It's pretty normal. And he was killed during Spencer's efforts to recover his child. Yeah. From its inception, the case has drawn intense public scrutiny regarding the court's decision to release him on bond, the propriety of charging Spencer for his actions in defense of himself and his child, the integrity of local law enforcement given its failure to preserve critical evidence. Yes, they haven't preserved a lot of evidence. A lot of evidence was spoliated. And it says Spencer, counsel, his family have criticized those actions. And they point out early on, the court made an expansive gag order, sealed the case, and limited access without hearings or findings. The Arkansas Supreme Court granted certiorari and vacated the orders, and they cautioned against courtroom closures or secrecy imposed without adherence to requirements under the Constitution. Several justices warned, and remember, there were 3 judges who wanted to remove her ass, but that didn't happen. And there's 7 on their court, so you just got to flip one. They said it's a troubling pattern of attempts to shield the case from public view. And they said that alone warranted reassignment. And it says, following the intervention, the court's rulings have reinforced and not alleviated concerns about impartiality and secrecy. The court has imposed compressed and impractical scheduling directives while discovery is going on, required duplicate filings before major deadlines, denied defense requests for additional time, despite late disclosures by the state. During the pretrial hearings, the court curtailed discussion of the Fosler's abuse and its relevance to the defense. It permitted the state to proceed with expert testimony despite belated discovery to that expert, and mischaracterized defense advocacy as improper. The hearing culminated in a public accusation of misconduct against a member of the defense team, made without evidence and in open court, resulting in that attorney's removal and exclusion. The attorney violated no rule and did nothing improper. The episode branded the defense as untrustworthy and reinforced the perception of hostility toward the defense counsel. Yeah, this is a disaster here. Absolutely disgusting. Absolutely disgusting here. When we're releasing, the court entered a sua sponte order limiting public and media access. Capping attendance and providing no alternative means of observation. Yeah, not like, hey, we're going to stream it into another room. And that order functions as a courthouse closure and mirrors the secrecy concerns. And viewed cumulatively, these actions create a perception the court has responded defensively to criticism and appellate review, and rather than correcting course. This partiality is further magnified by the nature of the trial. They say a substantial portion of the defense will focus on investigative failures by law enforcement, including the failure to secure and preserve evidence. And the court's going to be required to rule repeatedly on objections, cross-examination, impeachment of law enforcement witnesses, and expert testimony. And they say the court's long-standing relationships with local law enforcement create an appearance problem in this context. And they say regardless of intent, under the unique circumstances, a reasonable observer would question whether a judge with ties to the very agencies whose conduct will be scrutinized can be impartial. This further magnified by Spencer's current status as a candidate for public office, which I wonder if that was a tactical decision as well, making Aaron run for office, because now they could say it's political. Which if they did, that is, you have my respect for coming up with this game plan, guys. I think that's pretty good if that's what they wanted. So they point out that Spencer is now a political actor and by extension, a political adversary of a public official, expected to be a witness and with whom the court has worked professionally for many years. Spencer decided to run for office a significant part as well as a result of his experience with these officials and has campaigned on it. His criticisms constitute protected speech, but nevertheless place the court in a position where its rulings may be perceived as entangled with institutional loyalty or political context. And they point out where, recusal is required where impartiality might reasonably be questioned. Remember, guys, the appearance of impropriety is just as bad as actual impropriety. If it appears improper, that's just as bad because people will assume it's improper. And it says here the court presides over disputes directly implicating law enforcement. And where public confidence has already been strained by prior rulings, these previous things reflect a pattern that suggests the partiality and reincitement is necessary to preserve both the reality and appearance of a fair trial. So they request the court recuse from further participation and that the case be reassigned to another judge. And notice he's saying, I'm not objecting to an entry of an order without a hearing. And in the alternative, I request a hearing on this motion. So okay, that's fine. And now remember, guys, this case was set for the 26th. So next Monday, they were going to start. Because of all the weather that's going to be rolling in this weekend, the judge had already pushed it back to February 2nd. But they were still getting ready to go almost right away. This is the eve of trial pretty much. We are at the eve of trial. And this is their handiwork so far. Seller says not even Jew lawyers. Okay, well they're in Arkansas, buddy. There's only so much. There's only so much you're gonna find there, man. There's only so much you're gonna find there. Just be understanding of that. Be understanding of that. Oh my gosh, you guys are being ridiculous. What was I looking for? Let's see here. What was I looking for here? Sorry, Chad, I got a little lost here. They have different kinds of tribes in Arkansas, yes. And Jefferson Post says, Judge, no! Don't record this railroading. Yes, it's very true. And Jefferson Post also says, hey, court, remember that judge you spanked before? Yeah. And that's the thing. The Supreme Court's like, we already dealt with this woman. I guess we got to deal with her again. Yeah, this is very problematic what this woman has done. These meddling judges just don't understand what they're doing. And they don't care what they're doing at the end of the day. They're screwing around, causing problems for no reason. There's no reason for them to do this. Now, okay, what am I looking? Hold on, chat. Now, because of this stuff here, there are multiple emails where the judge is acting like an asshole to people, and you could see it in her demeanor and how she handles things. You're like, how is this woman being fair to anybody? Because one of the exhibits they cite is this email right here, and you're just like, okay, well, let's read it. Maybe it can't be that bad. It can't be that bad, could it? Oh, yes, it can. Yes, it can. So this is Aaron's attorney, and she says, hey, Judge, I wanted to bring your attention to the Pro Hoc Vice motion moments ago requesting to permit one of the firm's lawyers to participate. You're like, okay, well, yeah, one of the guys wants to participate on the case. Can we let them in? And oh, here we go. This is a lot better. Where is? Hold on here. Oh, I've lost my spot. Crap. There we go. No. Oh, crap. I lost it. No, come on. All right, guys. Sorry. Yeah, here we go. Sorry, it took me a second here. All right. So this is set on December 15th. And it's a motion for Pro Hoc Vice because they're going to bring in one of their attorneys. And makes you don't panic, chat. This is not. She's licensed in Minnesota, but she's still practicing. She's licensed in Minnesota, has been engaged in federal practice the last several years. She's obtaining her Arkansas license. She says, I typically have not submitted the order with these, so I wanted to ask what you prefer to do. And that's the thing. If you don't know, you ask. And it would be very helpful to know ahead of the pretrial hearing whether you allow her to participate in the hearing. Because, yeah, if she can't show up, don't make her travel for nothing. And it says, let me know what you want to do about this. Thank you very much. And this is 4:45. Later that night, the judge says, "I will not decide on the motion before the 17th." So she is on your list. "I will not be emailing or responding to emails from this day forth." Like, who the fuck are you? Who the fuck are you to decide you're not going to do that? Fuck you, I'm not doing this. Ah! It's just the way she's doing this is just absolutely fucking obnoxious as a judge. Now, that is one of the things they cite. That's one of the things they cite. Now, there's other stuff that comes up here, and we're going to get to these because we're going to skip over, the issue to go forward because that's a different thing here. We now get into some stuff that's absolutely obnoxious from Judge Gall. And look, if you think, hey, Luke, if you're out there, if you think I missed something, tell me. I'll go back and grab it and we'll take a look at it here. But these are just some of the things I found where it's like, what is this woman doing? Like, these judges are insane the way they abuse people here and they abuse the rights of others. Why is the judge using a Gmail account? No, the judge is not using a Gmail account. The attorney was. Oh, actually, yes, she is using a Gmail account. Oh my God, good catch on that, guys. Good catch on that. Yes. This bitch is using a Gmail account. Yes, a judge is using a Gmail account. What are they going to say? Oh, we're poor folk in Arkansas? Why does she have that? Why doesn't she have anything here? Like, they can't give her a Barbara Elmore at, lonocounty.ar.gov.us or wherever it would be for an email. But, like, yeah, that is trippy. That is trippy. This is just ridiculous. Just ridiculous of this judge. So anyway, there is a motion that Aaron and his attorneys trying to prohibit the use of prejudicial security during the trial. So what is the judge ordering here? So they want to prohibit the court from enacting prejudicial security measures. And what do they know here? Well, because this is a rural county, the Lonoke County Sheriff's Office investigated the case, and several officers will testify as witnesses at trial. And once again, the court, through its own motion, filed an order that no members of the Lonoke County Sheriff's Office will take part in this. Like, they can't be in the courtroom. Well, guess what they do typically? Like, guess who's in charge of your court security? Your court security is provided by the sheriff's department typically. So who's going to provide it? Well, they're generally the guys who do. And here you can see on the 4th, the judge made an order about this. So they cannot be in the courtroom. And it's issued solely for logistical and administrative reasons concerning courtroom security management. All other arrangements will be made by the court, which means the court will pay people. The court's going to be in charge of changing that out and doing it, which, it does at the time make sense. Give me 1 second, chat. So there we go. You guys can't stop yawning. I'm sorry. It's been a day, Chad. It's been a long day. It was a long night, too. But notice, she's like, I'll take care of security myself. All right. All right. Well, getting back to this, in that, but it didn't otherwise address how security would be managed. And I said the order didn't specify any need for enhanced measures, nor did the court request other agencies to provide security. At their most recent pretrial, the law enforcement presence was substantial. They had the Lonoke County Sheriff's Office, the Lonoke Police Department, the Cabot Police Department, which is another little the town where everything's at, the Jacksonville Police Department, and the Arkansas State Police. What are they going to do? Pit somebody into the wall? Those guys are only good for chasing people and killing them. Oh, hold on. Is somebody here? Did Steve pop in here? I see people saying something. The fact they do all caps in their orders. Yeah, well, that's a thing, though. Hey, Steve, how you doing, man? Hope you're doing well. Guys, you can find Steve's stuff over at stevegosney.com. Take a look at what he's got going on over there. Friend of the show, friend of, hopefully you guys enjoy him. Very smart guy out there. Keep it on lock. And notice, here's where they get to the part about this. There were at least 4 fully uniformed state police troopers standing at posts in the courtroom at all times, including one by the defendant and one by the jury box, with other police moving about, some waiting to rotate in a position. There are at least 2 additional officers and a security official outside the courtroom, several standing guard on each floor, and at virtually all functional entrances and exits. Now, some of this makes sense. Entrances and exits, okay, but having police swarming the courtroom is ridiculous. More officers flanked the elevators and stairs, while others congregated in other areas around the courthouse. There were usually more than 6 around the courthouse entrance, and the courthouse security used metal detectors and personal searches of all bags, including counsel. Now, having metal detectors on, nowadays, yeah, everybody has it, but I mean, up until a couple of years ago, there were courthouses I could walk into where there wasn't a metal detector on, and you would just walk through. Checking all bags, that's very common. Ladies, you take a person, they'll check. The public was not permitted to enter with electronics. That's not really unheard of. That's actually kind of a, depending on the situations, it's not as much anymore, but that used to be a thing. Now this is where, on top of all, here's how obnoxious it gets. Marked law enforcement vehicles with their blue lights activated surrounded the courthouse for blocks. They were positioned in all parking lots. Parking lots around the courthouse were closed for parking, leaving only police vehicles in them. Drones also circled the area. Yes. Now, they point out here at the ASP, and the ASP is the Arkansas State Police. And really, guys, in any state you're in, your state police or your highway, like in Ohio, they're not state police, but like the highway patrol, they have special uniforms. And their uniforms are different than regular police officers, and it's a very common thing. Their uniforms are considered typically, a lot more militaristic than traditional things. So, for example, here are Arkansas State Troopers. And when you look at them, this doesn't look to be too bad, but they wear things that are military in nature. They wear a Smokey the Bear hat, also known as a campaign cover. That is a, out on campaign. This is the hat, if you're in the U.S. Army going into Mexico, you're wearing. You're going to see this belt here. This is called a Sam Brown belt. It was created by British officers out in India as a suspension system. So this is kind of like this stuff is the original versions of load bearing equipment, because this belt would hook onto your equipment belt and keep it up. But yes, these are all military in bearing and military in nature. Do they look exactly like a Marine drill instructor? No, but they kind of do. They kind of do. If you guys don't know what I'm talking about, this is a Marine drill instructor. When they're coming in, they look this way. They look fearsome. They look intimidating. It's meant to exude authority. It's a very common thing. It's a very snazzy uniform look. It's the same way. It's the same way here in Ohio. They are, this is actually a very good example. Will this actually, hold on here. Trying to get this. Actually, here's a good example. Yeah. So, this is the Ohio State Highway Patrol. This is their honor guard, but still, it is military in bearing. The police are technically, by definition, are a paramilitary force. That's not to knock them. It is what they are. They're quasi-military in force. And for the longest time, a police officer's uniform looked like a military uniform. Obviously, it's different now. To be fair, when you see cops with their load-bearing vest and their plate carriers out in front, it looks like a military operation. But what's with the view blocking hat? Well, his head's down. If their head is up, they would see the brim would go along. But it's just to show you what these are. This is this uniform has military bearing in it. And it's the presence of the military in it. That's why it is what it is there. And it has that effect. They look like Marine drill instructors. They look that way. Barney Fife never looked like he was in the military. Yeah, well, they toned it down. They toned it down. But these are like drill instructors. They look like they're in the military. It gives that presence, that bearing. And, these architects, I don't know what they looked like in the courthouse, but I'm sure these guys were wearing similarly snazzed up uniforms at this point. So it's something to, now are they dressed like the New Jersey State Police? No, with their jack boots and everything. No, but it is if you guys want to talk about marching into Poland, I mean, here you go. The New Jersey State Police. These guys are definitely looking like they look like they're about to go do some stuff. But notice, this is a military bearing in their uniform. Now, they point out that while the ASP officers have their utmost professionalism, their president excludes formality and heightened stakes. Yes, because they're the preeminent law enforcement agency in the state. They say their regal uniforms are distinctive. They are, and more formal than others. Yes. And that was the head note there, footnote. And they say dozens of uniformed cops flooded the area, the courthouse and the courtroom. And they say their overabundant presence would be highly prejudicial. It will. Because people are going to be like, oh my God, am I to be concerned? Is Aaron Spencer dangerous? Are people going to storm into the courtroom and try to kill us? Yes, you must have security personnel present. But he asked that deployment not center on him and be limited to a reasonable degree. Because he doesn't want people to fear him. There's no evidence justifying a need for enhanced presence, where patrol vehicles line the streets and uniformed troopers flank the entry and exit points of every room and floor of the courthouse. And it says, absent particularized findings outlining the reasons, they're prejudicial against Aaron. And they point out it's also unnecessary that there's cops in nearly everywhere in the courthouse and lining the walls of the courtroom. And he wants an appropriate number of personnel and are reasonably dispersed throughout the courtroom in the area. And he asks that any cops that are stationed near him and who will accompany him in and out be dressed in civilian clothing and not have visible weapons. Because remember, Aaron Spencer's out on bond. So if anybody's going to follow him around, take one of these police officers, make him wear a suit. So now it's just another guy, maybe in his defense team, following him in, following him out, making sure he gets to where he's going. That's normal. And there are courthouses I've been in before, like one of the courthouses I've been in. The courtroom deputies, like the deputies actually in each courtroom, they had to wear a suit. They didn't wear their deputy's uniform. They had a suit they wore every day, and they had their badge on their, they had a badge that went in the pocket square holder. They had this like plastic, thing that hooked in all the way in there, and their badge was on, and like, who they were. And they carried heat with them underneath their jackets, and they got their jackets cut so they wouldn't print and do all that. Yes, it's a more appropriate way of doing it. And it says the court must do all it can to ensure the jury is not prejudiced by outside influence. And yeah, if they think, oh my God, Aaron Spencer's dangerous, that would be scary. It would be scary. And they say this creates prejudice and threatens the rights of Aaron, and it is. And the fundamental elements of due process is to have a fair trial with an impartial jury. And you're avoiding impropriety, bias, or prejudice. And they'll say that, the problem here is a murder trial where dangerousness will be at the forefront of everybody's minds. There's a problem here. There's a problem with having too many cops in there. The court must consider this request in light of the circumstances. And they say Aaron is not accused of violence towards a cop or the court. He has no history of violence towards security personnel or in-court participants. So, like, for example, Darrell Brooks, you got all those cops sitting around him because he's a fucking loon. This guy has had no problems. Aaron's not in custody, and he's not a flight risk. Those are two massive things. If I'm not a flight risk and I haven't tried to escape before and I'm not in custody, you don't have to be up on me. And neither Spencer nor his family have disrupted any proceedings. There has not been any particularized reason to deploy an abundance of armed officers during this trial. The pretrial hearing was dominated by state police troopers and their full uniforms. And then the Arkansas police and other agencies stationed at every entry point on each floor. These raise the obvious inference that Spencer is dangerous and the court took measures to mitigate the danger. Yes, either Aaron is dangerous or something about this means everybody's in danger. Having uniformed and armed police at every entrance and every bit of the courthouse creates an impression the police are prepared for violence, an escape attempt, or something similar. Yeah, it's very clear. We're prepared for something bad. And a member of the public seeing patrol vehicles in empty parking lots would infer someone dangerous was inside. And at a minimum, this deters the public from attending the pretrial hearings. And they say that defense counsel said that members of the public were deterred from attending because the police presence at empty parking lots indicated to them that it was not open to the public. Yeah. Imagine that. It's almost like it was planned. It's almost like it was planned. Almost like it was planned. They point out with the excessive circumstances here, there's a risk the juror will infer Aaron is dangerous, especially because the prosecution's labeling him a vigilante, or the court is biased since the court suggested that his view is to resolve disputes through personal force. And yes, the court made a determination that they're going to allow Aaron's wanting to go after people once he learned his daughter was being attacked. These labels and characterizations together with the show of force lead to the perception the court endorses the state's view that Aaron is dangerous and must be treated as such. And to protect his rights, the court needs to make it not excessive. And the Supreme Court's recognized that an overabundance of uniformed cops can jeopardize the defendant's right to a fair trial. And I agree. But they look at what's going on, the totality of circumstances, including the size of the community, the publicity, and its objectiveness or lack thereof, the number of officers and their location within the courthouse, and whether there is some other basis for the number of officers present. Like, what's going on here? The size of the community. It's a very rural community. The pretrial publicity. Oh, there's a shitload of that. Okay. Objectiveness. It's objectiveness. Everybody's in the tank for Aaron Spencer. It's not like, yes, if everybody in the county wanted to hang Aaron and lynch him from a tree, okay, yeah, I can see why that would be. We want extra cops around. The number of cops in the location of the courtroom, that's going to be critical. And then is there another basis for the number of officers? David says, is this the guy who shot the pedo? Yes. Yeah. Bama Law, good to see you, man. It's been a while. Hope you're doing well. Yeah, we're covering Aaron Spencer and how the saga has led up to the judge getting tossed off the case. And they say where the community is large, publicity is objective, and the number of cops is either limited or spread through the courthouse, courts have declined to find unconstitutional prejudice. However, where the community is small, the publicity is immense and may lack some objectivity, the number of officers is large, and the seating of those officers is grouped together in a place not normally reserved for cops or spectators, the courts have found unconstitutional prejudice. They talk about it for cases here. The Schutz v. State. That's a Florida case. They reversed a conviction and remanded because a substantial number of uniformed cops, not present for security or testimony, were sitting together in the courtroom near the jury. So in this case, the cops are just sitting in the courtroom. The cop, like, there's a trial and they want to make sure. No, if you're the police department, you don't get to show up and just wear all your shit in and, intimidate the jury. How do I think she paid for the security, Luke? I'm sure she paid it out of discretionary funding that the court has, because courts have a lot of that money. And do you think her down payments for the trials is getting refunded? I don't know. I don't know how that would all work. I don't know. And they say under these circumstances, the courtroom scene presented to the jurors dozens of officers clothed with the authority of the Jacksonville Sheriff's Office could not have sent the jury a message of official interest and a desire for a conviction. But the various informal and informal uniforms could have been seen by the jury as a live demonstration of the appearance of officers involved in the altercation with the defendant. They talk about another case where the court having allowed 3 cops to testify at trial to remain inside the courtroom in a space normally reserved for the parties directly in front of the jury. Meaning, it's not that the cops testified and stayed in the courtroom. Once you're a witness, you're done. You could go sit in the gallery. They were allowed to sit inside the bar, chat, so they're in the well. They get off the witness stand and they're hanging out and sitting behind the prosecutor, or sitting inside the courtroom, but they're not sitting in the gallery. Remember, if they're not part of the case, they should be in the gallery. You're not allowed to be inside the bar unless you have a reason to be there. And yeah, that would be a problem. I would not like that. That would be very prejudicial. Very, very prejudicial. Is this in northern Arkansas? It's in Lonoke County, outside of Little Rock. I just remember the AZ Rancher cop. What about him? What about George Kelly? And they said the court found the placement of the police witnesses inside the bar was a deliberate attempt to intimidate the jury. Yeah. And the prejudice was shown by the jury's decision to sentence to the maximum sentence. And the officers at Aaron's hearing were not necessarily testifying, but the core holding is that placement of police in numbers or arrangements which attempt to intimidate jurors is prejudicial. He got to sit inside the bar? Well, like the investigating officer can. Like the state's entitled to a representative to sit with them. Now, they also point out that courts have found they decline to find prejudice when the presence of officers is limited in number, if they're unarmed, in plain clothes. Even if they're armed, they could be in like plain clothes and were present for a specified reason, such as prior threats by participants on a victim's family or prosecutors. But this is a case where they found in a federal case there were unarmed cops and they were wearing plain clothes, meaning they were in shirt and ties. A security measure were warranted when 9 co-defendants were on trial for participating in an extraordinarily violent criminal enterprise. They say additional plainclothes cops and metal detectors was not unconstitutional when there's violent gang charges and threats have been made. They say courts have also held cases involving the death of a law enforcement officer or a CO, or a more violent defendant, more than one defendant, previous escape attempts, threats against witnesses, prosecutors, or victims are all reasonable justifications for increased law enforcement presence. So yeah, if a cop got killed, somebody's very violent, if you have multiple defendants, so you might be trying, kind of like the YSL trial. There were like how many people in the well at that point, including the defendants? Having a bunch of cops in the courtroom kind of makes sense. They need help taking care of stuff. They point out like there's, and here's the thing, like 5 officers in the court with 2 officers within 10 feet of the defense table is not prejudicial, where 2 guys were on trial for armed robbery and had histories of escape and violence. And they say, well, this is a murder trial. This case is in stark contrast to the other things. Aaron's the sole defendant. He is not engaged in conduct that would conclude he has a propensity towards violence in the courtroom. He has not in any way attempted to threaten, influence, or coerce Fosler's family, the pedo's family, witnesses or their families, law enforcement, or anybody else in the case. Nor has he demonstrated that he is a threat to anyone in the courthouse. He's not being held in pretrial detention. He's never missed a court date or given any indication he would escape. There's no prior criminal record, and he's never attempted to flee from law enforcement. He's not charged with murdering a cop or other government actor. There are no facts that align with this. And they point out when a court can't provide specific factual basis, it's an abuse of discretion. And they say an unreasonable number of cops presented for security can constitute unconstitutional prejudice. It totally can. And they say the court has not provided any justification for the stark increase in courtroom security that took place. If these measures continue, the right to a fair trial is in jeopardy. And this deprivation is evidenced by the fact that some members of the community expressed concern the hearing was closed to the public. After they see the army of police vehicles, the drones flying, and the entrances flanked by all kinds of cops. That they're stationing cops in his immediate vicinity. They're reacting to his normal movements, which we don't know that. That's the defense saying, which I'm assuming is happening. And they say refusing him freedom movement without an armed escort, which that's ridiculous. He's not in custody. He's not in custody. Or placing excessive armed guards by make it appear dangers anticipated. It's all going to intimidate the jury. And it says a number of the law enforcement have been subpoenaed by trial. Adding a number of other law enforcement officers from these agencies would also add a layer of prejudice, giving the appearance of official interest, support, or intimidation. And it says, particularly with the state's theory of vigilantism and the court's order endorsing the view, this police presence would be intimidating to a jury and suggest this man is Aaron Spencer's dangerous. He's out of control. We have to fear him. And they point out that while courts can have discretion in determining seating arrangements, you can't take precautions which would result in prejudice. You know, there's a substantial danger of just prejudice here. The volume and placement of the cops inside and outside the courtroom everywhere sends a message. And there's no justification for it. So they asked the court to reconsider it. Well, this was something that was pending. On top of all of this, another thing has been involved here. The press. That's right, chat. Not only the Fifth Amendment, not only the Sixth Amendment we're dealing with today, the First Amendment was being defended in this courtroom. So what happened? There was a motion to intervene and reconsider the order limiting courtroom occupancy and no recordings. So NLA Productions requested to intervene. They are a member of the media that had actual and concrete plans to send a representative to the trial. They say on January 13th, the court entered its sua sponte order limiting courtroom occupancy and no recordings. They put out this order only allows for 20 members of the general public to observe jury selection. And then after that, 55 individuals total, which is still going to be a lot of people. Oh, Bama law. Oh no, buddy, stick around. You'll be happily disappointed here. You'll be happily disappointed. And it says the court only allows one representative per station, newspaper, or other media organization, and then prohibited recording devices at any time, which is nonsense. And they say on January 19th, a representative sent an email to the court requesting formal permission to allow a pool camera in the matter. They say there's significant interest in this case. There is. And they want to ensure transparent access to the proceedings. They want the court to allow them to intervene. And they argue they have standing because they are directly impacted by the court's order regarding attendance. It has requested a pool camera, and news gathering receives First Amendment protections. It's true, it does. And intervention is proper. You know, they are not aware of a controlling precedent, but courts across the country permit news agencies to intervene in criminal cases, which is true. It's true. And they say the other recognized alternative, seeking a writ from a higher court, which also happens, would deprive this court of reviewing its decision with the benefit of argument on the closure advocated by a First Amendment and common law interest. Meaning, Judge, we could go up to that higher court, but we want to talk to you and see if we're hoping you be reasonable. We don't want to have to go get the Arkansas Supreme Court to fucking slap your pee-pee, but if we have to, we will. They also point out interventions a more efficient use of the resources, and they want her to reconsider. And they point out the Arkansas Supreme Court struck down the gag order. They're already saying, Judge, you got bitch slapped once, so think about it, honey. Think about it. They say in that decision, they noted the gag orders placed within a secrecy pattern, and they said that the circuit court's courtroom was at least partially closed to the public during the arraignment. And this is from the court case, guys. They say, although it appears the court intends to close further proceedings, we caution the court from doing so without an evidentiary basis and adherence to the required constitutional analysis set out in Waller v. Georgia. So, guys, remember, this is from when they smacked her down. And what did she do? She said, she pulled a Mr. Pink in Reservoir Dogs and said, fuck all that. I'm not going to do that. And as they point out, the right to a public trial is one of the most important safeguards in the prosecution of persons accused of crime. It is. And they point out that in Waller v. Georgia, if you want to close a hearing, you must advance an overriding interest that is likely to be prejudiced, and the closure must be of no broader than necessary to protect that interest. And are there reasonable alternatives to that? And then you must make findings to support the closure. And they point out that the January 13th order does not adhere to the Supreme Court's decision. Instead, it limits the ability, without making any findings related to the overriding interest, to be prejudiced, whether the restriction is no broader than necessary, and that there are no reasonable alternatives that could be found. Instead, the court concludes the courtroom will be crowded during jury selection. It concludes the order constitutes a reasonable and narrowly tailored regulation of courtroom access that preserves the defendant's Sixth Amendment right to a public trial while safeguarding integrity and orderly conduct of the proceedings. And they point out that there was no finding for an overriding interest. Let's see here. What? Autodoc saying she had been removed, had a thumbnail saying something about Elmore being removed already. I mean, it happens today, but it didn't happen earlier yet. Like, it's still a thing there. And they point out here that moving on, the Arkansas Code, state law says the sittings of every court, meaning every time court is in session, meaning the benches sit, the sitting is in court, shall be public, and every person may freely attend the sittings of every court. Meaning you have the right to just to walk into court. You could find a courthouse this morning in Arkansas, and if they're having court, you have the right to walk in and sit down and listen to it. As you should as an American citizen. And guys, I've mentioned this before. If you ever want to see how things happen in your world, go watch court where you live. If you live in a rural area, I know that's going to be tough, but I've said this before and I'll say it again. You call your local court up and you say, hey, I'm a citizen. I'd like to come attend court. When's the next trial? Do you have trial? Do you have a suppression hearing? Do you have something coming up where like court's actually going to happen? Or is there a docket I could come see? Do you have pre-trials coming up? You know, is there going to be arraignments? Are there sentencings? I would really like to see some of this stuff. And they'll tell you. And then show up. You know, you don't have to dress up like me. You could wear jeans and a t-shirt and go in and watch and see how this stuff works out. You know, you have every right to do that, and you should experience it at some point. When we watch it here on TV, it's not the same. Here on the internet, it's different. Like, it's go watch the football game at the football stadium. It's different than watching it on TV. You know, it's something you have to be there for. And maybe you're lucky enough to go watch a trial. It's going to be a trial no one else hears about, no one else ever cares about. But while you're in there, it's going to seem like the biggest thing in the world that you're dealing with. So, Cool Chill Names says, the court may ask why you want to be there. I'm a citizen. I want to come observe. I want to be there. That's a good enough fucking reason. That's all that fucking matters. Why? Because I fucking want to be there. I'm a citizen in this county, and I want to see how the court runs. Guess what? That's good enough answer. That's a good enough answer. Don't try to super chat way there. Yeah, don't do that. Vodka Blood says the button down looks 100 times better. I understand, but there's a lot of days, man, I'm like, I'm getting out of it. I want to be in like a t-shirt and a hoodie. So, but I also, you know, I try to wear the polo shirts as like a compromise. So, and real quick, there's some super chats here I need to get to. Jefferson Post, you got to get those hoppers and yes, jackboots like Massachusetts. Yes, you got to get the riding breeches like the SS would wear and the jackboots. Yes. Jefferson Post also says heavy police presence is akin to shackles. Yes, it's no different. It is no different. That's why we don't let people shackle in. It's also the same reason why you don't show up in a jumpsuit. Vodka Blood says, bring Steve on. I think Steve is Happy to be in chat. It looked like he didn't want to come on, but if he wants to, we can change my mind. And then Spuggun for £2 sterling. The King Sterling says, Sean, we did it. I don't know what we did, but yay. And then Radcon Hazard says for $5, my mom finally got on jury duty. It ended up being a murder trial, and now she has a totally different view of the legal system. Based. Good. Once again, like I said, having to go in there and be part of the, process. It's one thing to eat a hamburger. It's another thing to butcher a cow. Sometimes you don't have the heart for that hamburger no more. There's something to be said about, like, having to make the sausage yourself. Oh, you guys did a tower. Well, good for you guys. I'm proud of you. Well, Steve, if you want to come on, I'd be happy to have you on, but I don't, if you know anything about the case, if you want to come in, you can. Steve Ghazi for $20 says, God bless you, Sean. Well, thanks, Steve. God bless you and your family as well. Hope you guys are doing well out there. Keep up the great work. Thank you. Proud of you. Great analysis. Thank you. God bless. Happy to stay in chat. Well, like I said, Steve, if you want to join, be happy to have you on, man. You have great insights, but I also understand if you don't know anything about the case, you don't have to come up here if you don't want to. But I would be happy to have you on. You're always welcome. Then EDW says, for the suspender stab earlier, you earned it, big guy. Thank you, EDW. Oh. And then Brozufo for 10 subs. Real quick, guys, we're gonna get to that here. We get a no woo for that. Even though we don't have Clyde. We have Clyde at home. See, that's the Clyde at home. Maybe some other day. Okay, that's fine. Like I said, Steve, you never be a stranger here, man. Never be a stranger. Steve hasn't met Bonbon. I'm trying to work. I'll work on that. But they point out that going on forward, the order violates the law by prohibiting individuals from accessing the courtroom if that person is employed by a media organization. And they also point out the Sixth Amendment and Article 2, Section 10 of the Arkansas Constitution guarantee a public trial. Yet this case, intentionally or not, that's a fuck you to the judge, has routinely been hidden from the view of the public, and it begs the question of why? Why, Gary? Why? Why is it? Why can't we know these things, Judge? Judge Elmore, why has it been private? Why has it been private, Judge? Why are you making this private? Why are you doing this? What is the problem here, Judge Barb? What are you doing this? Why are you doing this? Why? Why? It makes no sense. It makes no sense. The administration of justice, the legitimacy of the decisions, and that's true, the legitimacy of the system made within the criminal justice system, now hang in the balance of this court's decision to open or close the trial. In this matter, it does. This is huge. Even if you don't live in Arkansas, this is massive. This is massive. And separate from the accused's right to a public trial, the press and the general public have a constitutional right of access to criminal trials under the First Amendment. Yeah, but I would still say at the end of the day, the Sixth Amendment overrides the First Amendment. The defendant's right to a fair trial is bigger than the public's right to a trial access. It's always paramount. The defendant's rights are always paramount. It's the defendant über alles. It has to be protected. It has to be protected. The court has the opportunity to protect the interest of justice by allowing camera pooling. They say the camera pooling serves as an alternate arrangement that would ease courtroom restrictions. And notice we do that, guys, where if we have a pooled camera, we don't need all the reporters. Everybody agrees we all have the pool camera and we all get to use it. PPP is fast as only a defense attorney talks like this. Well, yeah, you're not going to find a prosecutor doing this. And they said any restriction on the attendance is a restriction that's found necessary, must be found necessary. We're prepared to serve as the pool coordinator if we were to do this. And we would have the capacity to coordinate the pooling of resources and act as a primary provider of footage. And we would ensure the media presence remains orderly and uncrowded. And we agree to abide by the stipulations set by the Supreme Court in their administrative orders. And guys, what are these administrative orders? These are administrative orders known as rules of superintendents that the Supreme Court of Arkansas has set out saying, all courts, here are the rules you all must follow. You can set your own rules, but here is stuff you have to do with media pooling and things like that. Are we live on Kick? Yes. 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 Yes, very much. And guys, please remember, tell Brofuzzo, actually Brozufo, or is it Brozufo or Brofuzzo? If you got something from him, tell him thank you. Thank you for your support, your generosity. And they say using one video camera and one still camera placed in stationary positions outside the bar with other electronic equipment, not a component part of the camera, is located in an area remote from the courtroom, meaning all the transmitting and recording stuff. We can put that in another room. We'll just run some cable and run some signal and run some of that. We don't need all the shit right there. We have ways to do it. We won't require distracting sound or light, and we won't use any artificial lighting devices. Only removing or installing the camera when the court is not in session. Adhering to the prohibition of audio equipment to record conversations between attorneys or clients, or conversations between attorneys in the court held outside the hearing of the jury. Notice we have that problem with Tyler Robinson, which, God, it's another thing we got to get to this weekend. The media and Tyler Robinson, they were picking up the audio recordings at the defense table. And then the last hearing, when they were up at the bench, the camera focused in on the judge trying to read his lips. It's a problem there. Brozu Efso. Thank you. And it says adhering to the prohibitions. We won't record jurors, minors without consent, victims in the case involving sex offenses, and undercover agents. It also would have a dedicated kill switch, allowing for the immediate termination of all video, audio, and photography at the court's discretion, which that's not a bad idea either, saying, hey, we're going to kill it right now. James Reed, are we going to finish the O'Para trial tomorrow? Yes, we're going to catch up. We have to get going there. It's just this was going to be critical because all this stuff was in the balance until about 2 o'clock Eastern time. So I'm glad we know it now. And NLA's like, look, we'll give links to people to the media pool. They could download everything in there. We'll be a silent, invisible presence. Like, we're going to do everything we can. We're going to do everything we can to do this the right way. Well, that hadn't been decided yet. Because in the meantime, chat, filed this past week, January 16th. What happened? In the Supreme Court of Arkansas. When now it's getting seriously serious. In the Supreme Court of Arkansas, Aaron Spencer versus the state of Arkansas. A petition for writ of certiorari and other relief emergency consideration requested. Guys, remember, the trial starts the 26th at the time this was filed. 10 days away from trial. So they request emergency consideration to vacate unconstitutional orders issued sua sponte by the circuit court in the interest of maintaining courtroom security and the decorum and justice. Spencer's jury trial is set to begin in 10 days. The challenged orders operate as a de facto courtroom closure by limiting public and media attendance. And they point out Aaron has a Sixth Amendment right to a public trial and the First Amendment rights of the public and the press. The circuit court entered the order without receiving evidence, holding a hearing, identifying an interest. And they say this failure is stark because earlier in the same case, and these guys had to be, having the biggest fucking smile on their face because they get to say, this court already instructed the trial court that any closure must be supported by an evidentiary basis. It must comply with conditions under Waller v. Georgia. Notice they get to walk in there and say, hey, Supreme Court, you remember when we came in here before and you had to come in and help us, the judge? Well, guess what? You better warm up that pimp hand. Got to keep it strong. And they say, rather than a hearing, the court again imposed a sweeping restriction. And it said, as with the entry of the gag order, the entry of the security order was a plain, manifest, clear, and gross abuse of discretion. You notice why they did that right there? That was in the first court from the Supreme Court. That was right there. That was right there. So, what's okay, hold on real quick. Guys, if you're in chat, it's not for you guys to question other people. Just, I understand you may not like what somebody has done or what they do or not do, but leave them alone. It's not your job to question them. Just please leave them be. Please leave them be. So let's just chill. Everybody can chill, guys. We're all here to have a nice time. We're all here to have a nice time. Okay? M2, HMGHB. Good to see you, man. It's been a little while. Hope you're doing well. My dad was a bailiff for over a decade. He was assigned high-profile cases as the body man. He carried 2 sawed-off 20-gauge shotguns and a Model 19 revolver. In the 1980s, that makes sense. I'm like, why is he carrying sawed-off shotguns in the 21st century? But I could get it back then. But yes, yes. Yes. Let's see here. Guys, nobody's ruined anything. Nobody's ruined anything. Let's just calmate. Let's focus on this judge being a piece of shit. We can all focus on the judge, guys, okay? How about that? We all chill out. We all chill. We're all going to be like Fonzie out there. Because you know what? What's Fonzie like, chat? Fonzie's cool. So you guys are going to be cool out there. You're not going to make me do anything drastic. So when I do something drastic, it doesn't go well. We're just going to be cool. So what do they want to do? They want the court to grant a writ of certiorari and vacate the orders. Further, they ask the court to exercise its superintending authority to reassign this matter to a different judge. So not only is that recusal order, remember, we talked about the motion to recuse. And the motion to recuse had not been decided on yet. This motion to recuse hadn't been decided on yet. This is like a nuclear option. You're now going to the highest court saying, get this motherfucking judge out of here. this is it. Like, you are in trouble. You are in trouble at this point. Yeah. You guys, this is serious. And they say they're warranting emergency consideration because they're arguing the Jack Bauer rule. There's no time. That's why I always love Jack Bauer. If something happens, there's no time. I have to cut their eyes out. There's no time for ordinary consideration, meaning we got to get this done now. Now, what do they talk about? Yes, Aaron Spencer's charged for the shooting death of 67-year-old Michael Fosler. Based. Now, they go through the whole thing here, and if you guys don't know this, Fosler was arrested for numerous sexual offenses against Spencer's teenage daughter. The state later filed 43 felony charges against Michael Fosler. Several months later, on October 8th, Spencer and his wife awoke to the dog barking and realized his daughter was gone. As a result, they called the police, and he left the truck to search for her. Spencer located Fosler's truck with his daughter inside, and he forced it off the highway. After an altercation, Spencer called 911 to report he had shot Fosler, who died at the scene. You know what, Chad? That type of story.
Was this story based? Yes.
Absolutely based. Unfathomably based. So, yes. So we're just going to be nice, guys. Remember, we're all going to chill out. We're all going to chill out there, okay? I'm just saying. I don't remember. It's Somalia rules. And Mohammed Farah Aidid is the supreme warlord in Somalia. I don't want to have to deal with anything tonight. So, and they say from its inception, this case has drawn intense public scrutiny over the decision to release the guy on a low bond. That's not really, guys, like I've seen guys get charged with, like, the allegation is they raped a child under the age of 13, which means facing life without parole, and they were out on bond, like on a PR bond. It happens. And it says the propriety of charging Spencer, I agree, in defense of himself and his child. The integrity of local law enforcement when they lost evidence, including video of the events that concluded with the shooting. Yeah, there's apparently video that was out there, and it's gone. The police spoliated evidence. And then rather than permitting scrutiny, the court has repeatedly acted to restrict public access to information. They point out first the arraignment. The court was closed to the public. When defense counsel objected, the court refused to hear the argument and directed counsel to file a motion and brief, despite that the proceeding would conclude before any relief could be obtained. So they objected. And she said, file a brief. But we're still going to have the hearing right now. So what good is the brief? On December 10th, without holding a hearing or receiving evidence, the court entered a gag order and sealed the entire case. This required extraordinary relief and a petition of certiorari to this court. Remember, guys, this is the thing from a couple of months ago. Where the court decided, we're not doing this, and the Supreme Court had to step in and say, au contraire, mon frère, we are doing this. And the Supreme Court said, you're opening up the courtroom, judge. And the court's like, oof. And she had to suffer because she got felted. Ohio Hero says, stay safe during the storm this weekend. Oh, yeah, we're going to be fine. We're going to be hanging out this weekend. We don't have anywhere we're going. So we'll be all sitting here, on Saturday night. We'll probably be painting some models, drinking a nice hot cup of tea as the, Armageddon hits our way. After full briefing and oral argument, this court, the Supreme Court of Arkansas, granted the writ, vacated the gag order, holding it was a notice the language, plain, manifest, clear, and gross abuse of discretion. In light of the circuit court closing this, the court also cautioned the circuit court against closing further proceedings of the public without an evidentiary basis, according to the standards in Waller v. Georgia. And that's a Supreme Court case from 1984, Chet, is still valid law. Despite this history, on December 18th, the pretrial hearing culminated in what functioned as a partial courtroom closure when the circuit court ejected a member of the defense team from the courtroom without notice, findings, or adherence to the framework governing closures. The attorney, seated with defense staff directly behind counsel's table, used the phone in silent mode to research an evidentiary issue at lead counsel's request while a video exhibit played. Without any prior instruction restricting such conduct and despite no disruption to the proceedings, the circuit court abruptly stopped the video and ordered the attorney to be removed from the courtroom. That is such a fucking asshole move. Chat, you know what happens in court? Yeah, if you have a laptop, guess what? The prosecutor's sitting there. It's their home turf. Yeah, they got a laptop. They're sitting there belting out stuff, looking at things. Cool beans. You know what I got? I take my phone out. I fire up Decisis. It's a cheaper version of Lexus. And I start busting through looking for stuff if I need to. The Ohio Revised Code. I might look through different filings that have been available. All kinds of stuff. You have the idea that you're obstructing that. And if the judge didn't believe the guy was doing that, you could have said, stop, don't touch your phone. I want to see what you were looking at. And I've been in court before where the judge has done that. One time I was trying to write, my pen died, so I started taking notes on my phone. And the judge said, Mr. Martin, what are you doing? Stop. I want to see what's on your phone. And the judge, I said, here you go. And I said, the bail took the phone. I walked up there and I said, here, I'll turn it on, swipe. And it showed all the notes I'd been taking. And the judge said, okay, fine, please continue. The judge was concerned I was texting people. But I've also seen this with other people where somebody was dicking around on their phone and the judge got really pissed. But this idea of immediately ejecting the person is nonsense. Procrastination Station says, this is my county. Well, at least you're seeing that people are trying to save your county and do it the right way. Really, Catman says, isn't using electronics normal these days? And isn't it required to look stuff up and for accessibility purposes? Yeah, using electronics is normal, but, this judge has got a hard on here. This judge is acting like a spasmatron. But yes, attorneys looking up and researching issues. Sitting there fired up. If you're at trial and something goes down, yeah, the prosecutor can grab one of his buddies and say, hey, I need you to go in the office and look stuff up. Guess what? I'm my own cowboy. I'm sitting there fucking looking shit up, looking for things. Yeah, it's normal. I've been in trial or in a hearing where the court pulls up their computer and they're Googling something on Lexus looking for a legal issue to resolve. And they say, I found a case here, counsel. Will both counsel please take the citation down? You guys look it up. Take 5 minutes, read it, and tell me what you guys think. That's how this shit works. Yes. That's how it should go. So, can a bailiff arrest a judge? I don't think so, unless they're clearly breaking the law. Yeah, this judge is just being an asshole. But I could also see the judge saying, stop, what are you doing on that phone? And I could say, look, I'm on LexisNexis looking it up. And the judge say, cool. I was afraid that might be more normal. Like I said, if the court thinks you're fucking around on the phone, you're just playing Angry Birds. Yeah, you could have a problem at that point. So, They put out the circuit court subsequent statements made it clear the removal was prompted by her belief someone was reporting on the proceedings via social media rather than any concern related. Oh, okay, I didn't know that part. To witness intimidation, courtroom disruption, and other interests that could limit courtroom closures. So she was upset people were talking about the case. What a fucking cunt. What a fucking cunt of a judge. This is fucking disgusting. This is fucking disgusting. And I know that like Bob Mata and Ali Mata are doing a far classier job of covering this. But this is that cunt. This bitch. Barbara Elmore. The fucking scumbag. So, this is her abusing the Constitution. For some reason. We don't know why. Despite well-settled protections for reporting on public proceedings, the court suggested that any periodic public reporting would be prohibited. EW Raptor says, would a judge allow me being on Grindr in court? I mean, depends where you're at. San Francisco, maybe. Oh. Yeah. Yeah, and says, remember that woman judge texting her clerk talking trash about defense attorneys? Yeah, that's the other thing too. Yeah. But I will say though, for the amount that's happened, like I said, that judge who was upset about like making sure people weren't screwing around on their phones when it's their turn at the table. That same judge, when their phone went off and rang in court, they said, yeah, you know what, bailiff, please take my phone. And yeah, I got to hold myself in contempt here. And, I find it's, unlike other people, she didn't give herself a first chance at purging. Fined themselves $50 and went and paid the fine to the clerk and, did an entry for it. So, like I said, that judge that I'm talking about was very, very fair and very honest about things. So, name dropping defense diaries while cursing the judge. Well, Bob and Ali Mata are phenomenal. I love Bob's stuff. I love Ali. Those guys are great. If I'm half as good as they are, I know I'm doing something right. So I'll tell you like that. I was about to say, like, I haven't seen Bob around for a while. I think he realized, oh my God, this Sean guy's insane. What are the rules for like Apple Watches and iPads in courts? Like I said, when I first started practicing in 2014, like in Lucas County, the courthouse there, and you couldn't bring in a phone if you were a normie. You had to leave your phone down at the front, and they would check it and give you a tag that you could return, like coat checks. That used to be a practice in a lot of places. Nowadays, a lot of people can bring stuff in, but you have to have it off. For example, in a lot of courtrooms now, it's while court's in session, nobody better have their fucking phone out. Even defense attorneys. Even if you're waiting and it's not your time, no playing with the phone while the court's in session. That's kind of the new frontier. And half Seamus Racing. So just like federal court. Federal court's different. EW Raptor says, what if my cell phone collects information from my diabetic device? If that were the case, we would have to motion the court that there would be a limited reason for you to have your phone out, but you just have to have it in your pocket. Like, obviously, you're not going to screw around with it, but we would have to say, Your Honor, he needs to bring the phone in. It monitors an insulin pump or it monitors this thing, and we need to have it available. Would they allow exceptions? They would have to make that accommodation. I would argue. So, Yeah, they could if they want to. And have Seamus saying they collect from everybody was what I meant. That can happen. The court has the authority to control it how it wants to, especially a federal court. Ain't nobody going to get in the way of that. And they point out critically on January 13th. Let's get back to this. On January 13th, 13 days before trial, the circuit court sua sponte, once again, chat of its own accord, which is also the motto of the 75th Ranger Regiment, entered a new order invoking the interest in maintaining justice, limiting only 20 members of the media to attend voir dire, and then after that, 55, including all parties. Yeah, you need a blue card for federal court. Yeah, I don't have one of those yet. I'm working. Hopefully, I get admitted this spring to federal court. Then I can get a blue card. That'll be fun if I can get that done. The seating for media would be on a first-come, first-served basis until the courtroom reaches capacity. This prohibits all recording devices, including phones, watches, recorders, and eyeglasses, meaning you couldn't bring in your meta glasses. It said the circuit court provided no overflow, no alternative means, and no explanation. They say, as a result, the order operates as a functional courtroom closure. If you want to observe, you're going to be excluded once the cap is reached, even though the courtroom itself remains nominally open. The circuit court may know you're not allowed coffee either. You're generally not allowed to bring liquids into a courtroom. Water only. The only time you'd probably get away with having coffee in court is like if I'm the defense attorney at the table and like we're having like a hearing and I bring it in. But no, if you're the public, you're probably not going to be allowed to bring in coffee because it's a hot liquid. You might not even be allowed to bring in water. So, and it says the circuit court made no findings identifying any threats, and there's no findings demonstrating the restrictions are narrowly tailored. There have been no disruptions or any problems. And they say on January 16th, Spencer also filed a motion requesting recusal pursuant to Rule 211 of the Arkansas Code of Judicial Conduct. When they say her impartiality might be questioned, there's a pattern of rulings and conduct that create the appearance the circuit court has responded defensively to public criticism and appellate intervention rather than correcting course. And it's true. It's true. They got butthurt. And it says, due to the late hour of the filing and the intervening court holiday, the motion may not be docketed until Tuesday, January 20th, 2026. And they're saying we filed this, but we're waiting. And the problem is January 16th was a Friday. And remember, the 19th was MLK Day. So it's like, yeah, there's going to be some time in there, but they went ahead and just jumped ahead to the Supreme Court. And they say the recusal motion remains pending. If the circuit court denies it or refuses to rule the motion, which the court could say, I'm going to deny it. Or the court could say, yeah, I'll get to it, but it's outstanding. Yeah, I'm going to get to it later. Spencer asked his court to reassign the case to preserve the appearance and reality of a fair trial. Now, the standard for issuing a writ of certiorari, we're not going to get into this here. Basically, you could say it's apparent that there's been a plain, manifest, clear, and gross abuse of discretion, or two, there's a lack of jurisdiction. Well, an act in excess of jurisdiction on the face of the record, or the proceedings are erroneous on the face. Well, are there other adequate remedies? No. Now, the state of Arkansas, the Arkansas Attorney General said he could appeal all this later, which is a bullshit thing, but that's what they want to do. So they move on here and they say post-trial appeal would not provide a remedy for the right to a public trial. At least you can't undo it. Nor would it vindicate the rights of the public and the media to attend the proceedings, particularly in the event of an acquittal. And that's true. And once again, the guys, they're using magic. This is where generally you don't use magic words aren't a thing. But this is a phrase that the Supreme Court itself uses. And when you have language that you can keep quoting and you can keep beating on the table, you keep using it because they're going to say, yeah, we said that. Hell yeah. That's what you do. You keep beating the drum. So that's like one of the only times where it's not a magic word, but you just beat something to death and you wear it out. You wear out the joke. Now, they point out the sua sponte security order violates the First and Sixth Amendments, and it says the standard for closing the courtrooms. And the court has recognized that, trial public access is one of the most important safeguards in prosecuting people, and it is. They also talk about Georgia v. Waller, and they adopted the following determinations that if you want to close a courtroom, the hearing must advance an overriding interest that is likely to be prejudiced, meaning you have to show something is going to happen. That the closure must be no broader than necessary to protect the interest. And 3, the trial court must consider reasonable alternatives. And 4, it must make findings adequate to support it. I'm sorry, it's Waller v. Georgia, not Georgia v. Waller. I always get that wrong. They also point out there's a constitutional right under the First Amendment made applicable to the states through the 14th Amendment. And yes, guys, remember, the incorporation doctrine is out there. And the court has recognized that an accused may assert his right to a public trial by arguing exclusion of the news media, and public violates that right. And the Arkansas Constitution even more broadly protects the freedom of speech and of the press. And that's true. State constitutions can be more protective than the U.S. Constitution. And it says the sittings of every court shall be public, and every person may freely attend the sittings of every court. So every court hearing in Georgia, unless otherwise properly stated, it's all fair game. So if you live in Arkansas, go to courtrooms, go watch shit. And I want to get to this here real quick because somebody put it down. SW42MG. Thank you for being here. I don't think I've seen you before. Welcome. It says, I'm planning to go see the Austin Herbert trial in Wake County, North Carolina. The man is getting railroaded after being the victim of drunk Mexicans. Well, you know what? Good on you. Good on you for going. Because I never heard of this guy till now. But you go. Spread the word. Let people know what's going on. Let them know what you see. Let them know what's there. That's the public accountability is a real thing if the public gets engaged. But yeah, do your part. That is good on you. Good on you, man. Good on you. You're going in for $2. Says you're going to the Austin Herbert trial. It needs eyes. Is it broadcast at all? I'm curious to know or to look into it at all here. And I'm going to hold on. I'll make I'll pull up a Google page here. Austin Herbert. And North Carolina. Come on and raise up. Okay. Huh. All right, I'll take a look at this. Thank you. Procrastination stations. Do they trip about phones in there and tell you to keep them in your car when you are a defendant there? Oh, they do? Well, hey, every place is different. But like in Ohio, that's generally not a problem. And Shredder S07 says, I bet this judge likes Yellowtail white wine and real shitty housewife shows. I wouldn't be surprised. And Chuchin says, it's plain, it's manifest, it's clear, it's gross, and it's an abuse of discretion. Yes. Yes, and it's gay. So let's see. I didn't boom the screen. I wasn't. I pulled it up just so I could look at it later. I don't know what it's about yet. Let me see. Well, naked snake. Yeah, we're not doing naked snake. We don't do that here. We don't do that here. So the order closes the courtroom. Yeah, because ultimately 55 people, including parties, will be permitted. And they say, as a result, if members of the family and public occupy the seats available first, the press may be excluded. That's pretty tough. That's a pretty tough thing. The order does not allow seat reservations, which I don't think is, you shouldn't. And they say the absence of standards or procedures renders these exceptions illusory and arbitrary. And it says by counting counsel staff, and family members, the order ensures that most of the spots will go to trial participants rather than observers. And it says the circuit court requires the parties to submit list of team members and family, which together accounted for 40 people. 40 people. So, you know what guess that means? You get 15 people get to come sit in the courtroom. Even allowing for sequestration or scheduling absences, the order leaves only a handful of seats for the public and press attendance. And it says the restrictions are further exacerbated on where defense counsel and staff may sit within the courtroom. The circuit court permits only 3 members of the defense team to sit at counsel table and prohibits any additional staff from sitting inside the rail. That's pretty strict. That's pretty strict. Behind or close to the counsel's table. That's kind of ridiculous. Now, I get it if there's no room, but like we saw in the Brendan Banfield trial, there was a whole nother table. Or if you go into some courtrooms, you'll see inside the, in a lot of courtrooms, there will be, let me see here if I can find a good example of it. Help me out here, Google. Help me out here, Google. I need your help. I need your help. I need your help. I'm trying to find a good courtroom that's not like an appellate courtroom. Okay, here. That's actually really good. We'll use this even though it's the 10th Circuit. All right. So this is, actually that's not going to work. Hold on. We got to find a better one. Where would be a good courtroom pictures? Oh, come on. Come on. Shoot. Yeah, here we go. We'll do this. No, that's not a good one. Damn it, there's no good yeah, you know what? This is yeah, if she's as tedious in her courtroom, this is extremely tedious. We'll just use this as an example. All right, let's say, chat, the jury box is right here. Like, here's the jury, okay? And you have the tables facing this way instead of long ways, they're sideways. Normally, there are chairs sitting right here inside the bar that just sit there. Usually nothing's being filled. But like during court, like let's say there's something happening beforehand, I can walk up and come sit right here. And that's expected of attorneys. We don't sit in the back with you commoners. We cross the bar and we go sit. Now, in this situation, though, there are going to be no chairs in here, which is a problem because you need to be able to work with your team. And like I said, we'll put the jury box right here. This is just ridiculous, though. It's ridiculous. He's John Madden mapping out plans. Well, I'm just making sure it helps. Barnstable County Courtroom. Yeah, that might help us here. Let me try this. That better not turn me into, like... That better not give me, you know, that better not give me, oh, actually, this is a good example. This is a good example. Thank you. Thank you very much. All right, here we go, guys. This will be a good one. This is good, actually. So here's the court. Let's say here's the bench. Here's the jury. You know, you got your parties sitting. But like, you know, how would you do that? Like, look how crowded a courtroom could get. Look at all this. It doesn't take much. There's 50 people in this courtroom right now. So, yes, boom, right there. You got to go. Yeah, you go like this, and you go boom. But then you have your, you know, they come in and they shoot the gap, and he's going to try to cover it, but he won't catch him in time. So there you go. Yes, there you go. There you go. Anyways, let's get back to this. Yes, they all sit at different heights. They say as a result, defense staff are required to sit in the outside and occupy seats that would otherwise be available. If the court allowed space inside the rail to be used, a meaningful number of public seats would be freed. But it's almost intentional. These restrictions are difficult to justify given the layout of the courtroom. The courtrooms are available at oh. Here we go. Here we go, chat. Ah, here we go. Wow, that's looks like the Alamo. Look at the Alamo here. Gosh, that's a rough and tumble courthouse. Ooh, that's old. Wow, that's beautiful inside. That's old, and I like that. Okay, so here we go, chat. Here we go. Here's the courtroom. Here's the courtroom. This is a little different. I like it. I like old courtrooms. Look at that woodwork and stuff in here, 1928. Look how beautiful that is. It needs a little tender loving care, but like the stadium seating. But like, yeah, that's all real wood. It's not paneled stuff. I like that. I like that. It is a big courtroom. That is a very big courtroom. But that's how old courtrooms were. They were big like this. But also, this is probably the only courtroom in the courthouse, so you could make them bigger. J-Rock says, I really like old Southern courtrooms. Yeah, I did play football. Jeez. Bama says, why do they look like penises? Why are you thinking of penises? I love old Southern courthouses. Like Ohio's got a bunch of these courthouses that still have the old timey charm instead of the new charm. But like, guys, this is the thing. This has real wood in it. This is not the modern stuff today where it's just like laminated over particle board. You know, it's pretty good. I like this a lot. But notice they're saying, hey, if you're a defense team, you know, obviously hanging out right here would be tough, but you can hang out like right here. Like there's other ways they can set up this courtroom. It's a little tight. It's a little tight, but there's ways to work on it. There's ways to work on it and fix it. There's ways to do it. There's ways to handle this. And I mean, yeah, here we go. All this seating is going to get eaten up. All this seating gets eaten up right away. So I will say this is beautiful right here. That is actually very nice. That is very, very nice. So Rainbow Zen says, it looks like the courtroom where I got one of my divorces. Yeah. Well, there's beautiful courtrooms all around. There are beautiful courtrooms all over America. There's some amazing ones out there. There are some beautiful ones out there. There are some, you know. Let me see here. There are some really good ones. You just got to find them. You just got to find them and look around and, um, take a look for stuff. Like there's the TISM Sean has. Well, you could have some courthouses were big and formal, and this is the biggest at the time. Many times it was the biggest building in your town or one of the biggest buildings because the people, the community realized our court is prominent. We believe in the rule of law, and our courts are important to us. And here's how important we're making it, that we're spending money and making this room beautiful, and it's architectural, and it's appreciative, and it's highfalutin. There's a reason why courts were done that way. There's a reason why courts were done that way. So. Melissa says you're informative, but Jesus Christ, stop yelling. Oh, my apologies. My apologies. If I'm being too loud, let me know. Yes, it's a representative to divine order. Yes. Courts, Afton, I was going to say it. Yes. Courts and cathedrals. Yes. Similarly important. All right, let's get back to this. These restrictions are difficult to justify given the physical layout of the courtroom. The gallery alone has 75 individual seats. Well, yeah, if there's 75 seats, why are we doing this? Why are we doing this, Judge? Huh? Not benches. They're individual seats, and you can see that. Hold on here. What's going on, chat? And they say council tables are large enough to accommodate more than 3 permitted staff members, which would free up additional seating. There's also a largely unused area on the opposite side of the courtroom from the jury box, occupied by a larger conference table. We could see that remained empty through most of the pre-trials. And during the pre-trial, additional chairs lined the wall of the courtroom, providing additional seating. And that's a problem. So the judge has already done this, and she's taking things away. There are no alternative means of public access. There's no overflow room, audio feed, video feed, or any other mechanism. This says, on the contrary, the order imposes sweeping technological restrictions, banning all devices, including cameras, cell phones, Apple Watches, iPads, and everything. And as written, this order extends to tablets, laptops, and phones used by counsel, even when not used to record, which, once again, the judge is sloppy. That's a problem here. Well, what are you doing? What are you doing? This is ridiculous. This is ridiculous. This is absolutely garbage. This is it's nonsense. It's nonsense, isn't it? Now, the judge might say, I didn't say that, or I didn't mean that. It's like, well, but what do you mean? What do you mean? Because it doesn't make any sense anymore. It doesn't make any sense anymore. I don't know what you mean at this point. It's not clear. It's not clear at all. Hold on here. What am I looking for here? All right. Wow. Well, but it's like, what do you mean for all this stuff? And it's, I didn't mean it, but yes, this is crippling the defense's ability to manage a case involving extensive digital discovery. Like, how the hell are we supposed to do our jobs? The judge might say, I didn't mean that. It's like, well, what are you going to do? What are you going to do here? What are you going to do? There's the restriction confirms the court doesn't intend to provide any audio or visual accommodations. And the order closes the courtroom to only the people who can get there. The security order was entered without an evidentiary basis or adherence to the required analysis. And it says it's awesome when you can cite stuff. And you're citing your own case and you're saying, Judge, you said not to do it. And they did it anyway. The guidance provided to the circuit court in the writ of certiorari in Spencer v. State, the previous dick slapping, the court entered the order without an evidentiary basis. The circuit court entered the order sua sponte, without a motion, without notice or hearing, and without receipt of evidence, meaning there was no hearing taking place. Nobody submitted briefs, anything. No record was developed before the circuit court to demonstrate why there was there. There was no evidence presented that there was an overriding interest to be prejudiced, how broad the closure might be, or what alternatives might exist. The court made no findings. There were no findings demonstrating the restrictions were tailored. The court did what it wanted. It made a conclusory statement that the order constitutes a reasonable, narrowly tailored regulation of courtroom access that preserves the Sixth Amendment right to a public, and notice it says pubic trial, while safeguarding the integrity and orderly conduct of the proceeding. Well, without anything there, it's just a perfunctory pronouncement. It's all garbage at that point. And they say the trial is beginning January 16th or January 26th. The order operates as a functional courtroom closure. And they say for these reasons, it's apparent from the face of the order, it's a manifest, clear, gross abuse of discretion. Notice, you keep hammering those words over and over and over and over again. And they point out, finally, Your Honors, exercising the duty of superintending is appropriate to reassign the case. They say the court has exercised its superintending authority to grant expedited relief when a circuit court persists in conduct that undermines public confidence in the judiciary. Exercise of that authority is appropriate here. They're going in for the kill, chat. As detailed in the what is messaging me here? Okay, well. They say as detailed, the circuit court's motions after the remand from the Supreme Court don't reflect correction or restraint. Despite this court's express mandate, which it's nice when you can say this because they can just hammer it home. Emphasizing the presumption of openness, the circuit court continued to restrict access to public records, excluded a defense attorney from a public pretrial hearing based on suspicion of reporting, and ultimately entered an order that at least partially closes the courtroom. These don't occur in isolation. They were accompanied by an extraordinary security force at the December pretrial. And they say, although Aaron is not a non-custodial defendant with no history of escape or violence, at least 4 and sometimes as many 6 troopers were stationed inside the courtroom at all times. And this is, they talk about the cops were all over the place. All attendees were searched, electronics were banned, and even defense counsel's briefcases were inspected. That I got a big fucking problem with. Like, if you're going to inspect it, I'm pulling my papers out of it. I'm not letting you rifle through that shit. That's fucked. That is absolutely fucked up. You know, from the outside, the court appeared closed to the public. Counsel has reason to believe an even greater show of force will accompany the trial. Yes. And they say these measures will discourage public attendance, insulating both the state's conduct and the circuit court's own decisions from contemporaneous scrutiny. You know, when they say the message is that Spencer is too dangerous, the public can't be trusted to witness it, and that those who speak about what occurs may face sanction. This fosters an appearance of bias and erodes confidence in the process. There's also, once again, that he's a public office, which, once again, that is a brilliant move on their part. I'm sure Aaron Spencer would be a phenomenal sheriff, but if they had a tactical consideration here, once again, bravo for fucking doing this. Bravo for doing this. Bravo. they point out there's a problem here. There's bias. And they say, well, where a court responds to appellate correction by not conforming its conduct, but by entrenching it, court intervention is necessary to preserve the appearance and reality of impartiality. So what do they ask? To grant the emergency consideration, issue the writ, vacate the orders, and exercise the authority and reassign to a different judge. Respectfully submitted, Michael Kaiser and Aaron Casanelli. Once again, guys, I wish I could I wish I could call these guys and be like, you the fucking man now, dog. But yeah. Fucking bitch slap. And then today from the Arkansas Supreme Court, in a formal order, remember, guys, at the first time this case went through, the court was 3-4 on removal. They couldn't remove her, but the three of the judges wanted to remove her, but they couldn't get enough votes for it. Well, now, here's what happened. And the state had till yesterday to respond, so they immediately came up with this order. Petitioner's writ for certiorari, and all this really requested. Expedited consideration granted. Petitioner's writ for certiorari granted. Writ issued. The circuit court order limiting court occupancy and no recordings vacated. 23rd Judicial Circuit Judge, Division 1, the Honorable Elmore, removed from these cases to be reassigned to a special circuit judge appointed by this court. 3 of the judges, remember, guys, there's 7 total, so it was a 4-3 decision, would deny the petition for certiorari. The case is immediately stayed pending this court's appointment of a special judge, meaning now it's all up in the air. It's all on hold. Signed and executed by the clerk today, the 23rd day of January 2026. So what is this, chat? This is a monster kill. They got everything they wanted. They got the judge booted, and they got all those orders tossed. Absolutely based. They found Judge Elmore, and they broke it off in her ass. I mean, they just fuck. They were gorilla pimp on her, man. I mean, they just came in and just, whoa, man. Woo. They just turned her inside out. So, Kathy, your realtor in Jersey. Kathy, good to see you guys. Yes, guys, remember, buy, sell in Jersey. Kathy's your person. Yeah, what? Yes. Yes, total victory. Or if you're playing Unreal Tournament, godlike. Unstoppable. Yeah, they prolapsed her. They did bad. If only this had happened in Delphi. Yeah. Remember, though, you got to find judges who aren't afraid to do the right thing. But this is actually embarrassing for her. This is really embarrassing. Like, this idea that the Supreme Court's like, yeah, you're done. And not even a chance to, like, we're gonna have an oral argument. Nope. We're reading this good enough for who it's for. You know what, Judge? You're out. Afuera. Like, that's really bad, guys. Like, the Supreme Court of Arkansas is like, this bitch again. Fuck her. Like, that is embarrassing. I would be really fucking embarrassed if I were her. I mean, it's just not good. It's just not good. You know what I mean? Because, like, here's what happened. The writ of certiorari got filed on the 16th. By the 22nd. So by yesterday, they had till Thursday to respond. And they filed it Thursday. By 1 o'clock, Meaning they already decided this probably this morning. So they got this by the end of the day. They read it and they came back and slept on it and said, yeah, fuck her. No oral arguments, nothing requested, nothing sought out. They immediately were just like, done. Dunsky. Dunny. That says a lot when the court just bitch slaps you like that. You know, like as Jay-Z said, it was like Gorilla Pimp, get up on that killer shit. They were all up on her. Yes, Speransky is right. A new villager has come to your courtroom. Yes, that is it's amazing news. It's good news. Yes, Safa. Yes. Flawless victory. And it's one thing to, like, the court saying your gag order is bad. But within a year, like with it twice in a calendar year, your state Supreme Court butt fucks you on the same case pre-trial. These extraordinary writs of certiorari, guys, like, here's what you need to understand. Like, if you did this 100 more times, I can't guarantee you Aaron Spencer would get the same result. You know, like, getting this is all, like, Aaron Spencer better go buy a goddamn lottery ticket right now if I were him. Go buy a lottery ticket right now. Because you are in lottery ticket territory. Like, what's Powerball at right now? Hold on. What's the Powerball at right now? Do they do Powerball in Arkansas? Oh, it's only 20 million right now? Dang. Yeah, they do Powerball in Arkansas. Great. He better go buy a ticket. If he doesn't, he's a damn fool. Because that was huge. It was huge. But yeah, that is a really embarrassing thing to happen right there. I got a phone call. Is she out? Yep, she's gone. Vodka Blood, yeah, as I said, if the judge did the right thing, the system would fall apart. Yep. DM says no stream on Rumble. I try to do Rumble every once in a while, but usually it's only like 2 people watching on Rumble anyway. And half the time Rumble, like, it's a pain in the ass to get it set up. So not tonight, sorry. So, yeah, the Arkansas Supreme Court went in raw. Yes. It's not the Supreme Court of Arkansas, it's the Arkansas Supreme Court. Just like in Ohio, it's the Ohio Supreme Court. The Supreme Court of, you reserve that for the United States. Peter Sitchell for $4.99. Thank you. It says, the state Supreme Court kicked Barbara so hard her fallopian tubes fell out. Pretty much. Kathy, your realtor in New Jersey, for a $1.99 super sticker. Thank you. Asphalt Sally says a win for justice. It is a good thing. This is a good day for justice. So, Procrastination Station says, by the way, the people of this county overwhelmingly support Aaron did, I believe. I think he will win this case. I think so too, but it's a danger. It's still a risk. A jury trial is not guaranteed. It is a coin flip at the end of the day, regardless of how good your case is. He shouldn't have to stand trial. So hopefully we can get a judge who's not going to be a retard about this. Malcolm Combs says, I don't know if anyone has said this yet, but Russell Gray has a new lawsuit. Really? Huh. Interesting. Who is he suing now? What hooker is he suing now? Did another hooker, trick him and go to Olive Garden with him or something? What's he crying about now? And then Libby says, you need to hear Judge Azcarati at the end of the day speak to the defense attorney in the au pair trial. If I was that attorney, I'd be mortified. I'll take a look at that. We're going to watch that tomorrow. We got to catch up, but not tonight, because this Aaron Spencer stuff, I told you guys we were going to do it. I saw at the beginning of the week this happened. We saw that there was a deadline by Thursday. I thought we might not hear anything till Friday night or Saturday morning, and I wanted to get us into it. I thought tonight would be a good night for that. So I apologize, chat. We will continue the Brendan Banfield trial tomorrow. I don't know the timing yet. I got some stuff in the morning I got to do, and then probably in the afternoon we'll get after it. We'll get after it. So, but thank you for I'll take a look at that. And Malcolm, thank you for the super chat. Trenton says, "Can this judge could have a support group with Judge Glanville down in Fulton County?" Yeah. Yep. Sparky's Tech Corner, yes. Killionaire. Yes. I love that when you're playing Unreal. Ludicrous kill. Holy shit. Aaron did what Aaron did is a man's duty. I applaud him. Yes. Is the pedo her dad? Yeah, it seems like it. It seems like it. Afton says, I was not hopeful the judge would get tossed. Neither was I. Robin Hood says only $20 million. Well, normally like Powerball's like $800 million. When it's only $20 million, you're going to end up with like $15 after taxes. Someone just came to $1 billion ticket. Oh, that sucks. Jefferson Post says, I hope she likes more recusal motions in her future. Yeah, you got to be careful, though. I mean, especially if you practice in front of her, you got to be careful with that because that's something else you have to consider. How, what's that going to affect not only this client, but your other clients in the future? So, did the Supreme Court hand out lube? No, there was no lube. So, Russell's trying to shake down an employer for ADA violations. Well, he doesn't have any. He tried to extort his employer after getting a $20K in a settlement. He asked for $200 instead. Well, Russell's an idiot. So. Hashtag says this makes up for the loss of your air fryer tonight. Well, 07's in the chat for the air fryer. What happens in terms of the special appointment? Does that Arkansas Supreme Court decision, or does it go to the jurisdiction of the municipal or the county? No, the Arkansas Supreme Court's going to find a circuit court judge to take the case. They're going to figure out what to do. They're probably going to get a judge from out of the area because that appears to be part of the problem. But they are going to pick a judge, and they're going to find one. Right now, the case is on hold till the Arkansas Supreme Court does something. So if they don't pick a judge until 3-4 weeks, nothing happens for 3 or 4 weeks. The case is on hold till they put a new judge in. Have the dissenting judges given their reasons yet? No. And I don't know if they're going to write an opinion. Is Clyde being good today? Yes, of course he is. When is he not being good? That's the real question you need to ask. Is the trial still happening? No. It's all on hold. It's all on hold. Everything has been continued indefinitely until the Arkansas Supreme Court puts a new judge in place. No judge is going to take a trial like that's 2 days away. And all those orders have been vacated, so everything's a mess now. It's all on hold. Autodoc says, can a motion for summary judgment ever be taken to an appellate court or an interlocutory thing? Yes, as long as it's a final appealable order, you could take a lot of things up to an appellate court. Whether they accept it is different. They generally don't. There's generally not really a mandatory acceptance of an interlocutory case. Generally, they'll tell you, deal with it and then come back to us later. Oh, a lot of 07s. Yeah, just, everybody. It's by a stove with a convection, yeah. Yeah, the air fryer just got about a 21 salute, yes. Yeah, Bob's going to have to go home, but that's good because Bob can get out of there before the fucking storm. So, Bob, if you're watching this, I doubt you are. Get back to Chicago safely. Get back to Chicago safely. So, should we expect a trial in 3 to 6 months? Probably. I doubt anything. Like the defense, hopefully they're going to get a reasonable judge who will give them some time to work on stuff. Does the defense refile all their previously denied motions? Yes, I would. Because you can show the judge was biased. I would refile everything. But wait till the new judge is there. Could the new judge dismiss the case? Yes. Yes, Reisner, that is the correct thought. The judge could look at this on a motion to dismiss and say, yeah, I'm tossing it. It's a new judge. They are not bound by those decisions. They could say, I'm not doing that. The other judge said no, but they could say, this new judge could say yes. Say yes. Bob's already home or on his way. Good. Is going to Chicago ever safe? Yes. The Matas are already left on the way. Oh, Allie went too? Oh, good. Well, hope they're both safe. I hope they're both safe. I need to reach out to them. It's been a while. But just been busy. Busy. It's already like the year's over, man. If the case gets tossed, we're all buying lotto tickets. Yeah. What do they need to toss with prejudice? That's up to the judge. I'm sure that they, it's not ripe for that yet, but I could see it happening in the future, especially with discovery issues. Like that discovery issue could cause it, but who knows? The new judge is a full restart. Basically, it is. You're getting a different person to handle this now. When are me and 2.0 going to do a trial road trip? I don't know. Maybe in the future. Who knows? But something's got to be reasonably close. And I have to be able to take time off to get to there. And, so does she. There's a Youngblood motion with dash cam. Yeah, there is potentially. There's a lot of stuff that's going on here. There's a lot of problems. There's a lot of problems here. Oh, Jefferson says the Barnstable Superior Courthouse was built in 1831. Well, thank you. Yeah, it looks like it. It looked like it on there. Let's see. Did I get anything else? Trying to check chats. Rozuf Efso took care of him. I think I got everybody. I think I got everybody here. Yep. No, I think I got everything. Just making sure I got everything done. Making sure I caught everybody. If Aaron wins sheriff, does he have a better chance of dismissal? No. Yeah, lost evidence could be a big reason to dismiss. And what if he's elected? He's in charge of the people jailing. I mean, that could happen. Just because you win an election doesn't mean you automatically get out of trouble. The only time that works is if you're president. Does the DA have a hard-on for this guy or what? I mean, like I said, I don't know. There was a Reddit mod that went on side scrollers. That's hilarious. But, I mean, here's the thing to think about. I don't know if the DA has it, because Fosler was a police officer in the area. They might have a hard-on for him for that. There's also, this is where, once again, I have the consideration we have to think about. This is a political philosophy idea. This is about the state preserving its monopoly on violence. And one of the ways the state preserves its monopoly on violence is it punishes people for using that monopoly themselves. The state has the monopoly of violence. We give it to the police and they have guns and they handled our business. Vigilantism is a rejection of the monopoly on violence. It's the democratization of violence, that I don't need you anymore, the state. And it's a threat to the state. And it's a threat to their power. And I'm not talking about at a philosophical level, you are threatening the power of the state if you can issue violence on your own. Part of our social compact and what we buy into is that we endow and we grant unto the state that monopoly of violence, because the state is only given what the people allow it. I'm not going full anarchist. I'm just saying, like, I think that's probably what's going on in there. I think that's probably part of this was. Could it be a corruption issue? Sure. But I think at the end of the day, there is another overriding concern of, do we want people taking the law into their own hands? And yes, in this situation was dead on. But also, let's say the neighbor kid down the street says, oh, Bob down the street touched me. And dad walks down there with a shotgun and, do we really want that? I mean, remember, as George Carlin says, think of the dumbest person you know, and then half of people are dumber than him. Do you want those people leading a lynch mob? Nah, I don't. And I think, like most people leading a lynch mob, I wouldn't trust them because they're idiots. Now, me, I would be the most benevolent and most intelligent tyrant of all. We all think we'd be the most intelligent and benevolent tyrant. But at the end of the day, there's a problem with that. Because, once again, that's how society breaks down. So we turn to the government and say, we grant you the monopoly of violence because we expect you to be impartial and fair and just in your use of that violence. So, yes, everyone thinks they're the philosopher king. Yes. I hope that makes sense. I hope that makes sense out there. Yeah, so the people don't have a natural right to use force. How can they grant it to the state? We do have a right to use force. You do have a right to use, like, it's not even a right, but it's your ability to use force as a human being. That's the only way you could protect your rights. Rights have to be protected. If you can't protect your rights, you don't have rights really anyway. Like private property, if you can't stop somebody from coming onto your property, you don't really have the right to private property. You have the construct of, like, I have the right to private property, but in reality, you don't. So, no, force is everything is backed up with force. Government is built on force. Like, that is just a foundational thing there. I don't know, like, I mean, like, I don't, geez, I mean, like, are we going to get into, like, a debate here about that? But that's just something to consider. I think you have to consider that about how this is all structured. Force is what protects your rights because you have the right to life. Okay, well, I'm going to take it. There has to be that or else. And it's like, or else what? I will defend myself. That's, how I would phrase it. That's how I would phrase it. So, I'm the man who would put people in helicopters for ham. Yes, I would. I have no illusions that I wouldn't be benevolent. Well, that's fair. At least you're honest about yourself. Radcon says the DOD admitted we have direct energy weapons called the DEW system. We already had the DEW line. Those were radars running in the north of Canada. But I'm not surprised we have laser systems. Like that's like the obvious thing. So, unlike the state, we can't use force to impose our will. We can. But as society, we've given the state the ability to do that instead. The state is force. Yes, it is. Yes, it is. And Monopoly on Violence, you guys can read Max Weber. He is a political theorist, early 20th century. He wrote about this stuff. Politics is a Vocation. It's a very good book. It's very good reading. And, he really talks about the monopoly on violence. I mean, other people do too, but I really understood it when I read Max Weber. So. Dern is saying, what I'm saying is if I have a natural right to use force, granting the state doesn't forfeit the right. No, because you still, like, you don't lose the ability to, you could go do it, but now you run the risk of the state using, like, punishing you for that. That's where it is. Does that make sense? I don't know if that makes sense. Very eloquent. I'm pretty retarded. I don't know if that really made any sense at all. It made sense to me. Yes. To quote Colonel Dubois, force is violence, the supreme authority from which all other authority is derived. Yes. Quoting the great Colonel Dubois from Starship Troopers. So, are we going to do trains next? No. I am in fucking miniature mode. I have been making motherfucking things. I have been painting shit while we've been doing the trial for Brandon Banfield. Like, dude, we are making progress. I made the mortar team. Check these dudes out. Check them out, yo. They're having the time of their life. You know, we got a mortar team going. I got a new set of guys we're working on. Got like this dude right here running along. He's just running along with all this stuff. I got to figure out how to make their faces brighter because I didn't realize how dull their shit's looking. I mean, this guy, not gonna he's looking at his MP40. He's like, how do I load this? Like, there's all kinds of stuff we're working on here, chat. Yeah, I need to make a brighter skin tone, I think, for some of these guys. It did not work out as planned. So, yeah, I need to work on that some. Do you feel in control? Yes. And then what? Yes. Waka Waka, you know, it's time for Africa, to quote Shakira. Are we listening to Casino tonight? Yeah, we probably will as we're working here. Jackbox soon, or can you stream chat while doing it while you do bottles? Yeah, we could do something. We could do something here. I hope they don't turn on you with all their state violence authorities. Well, I mean, that's also things, yeah. Yes, we're trying to land. If you haven't read George Freeman, check him out. Where's the book? Yeah, this guy. Yeah, this is a great book. You want to read about a guy who predicted Europe getting felted? This guy. Chugi Show says, I would be a tyrant. I would be a love tyrant for offering the free shrooms. Oh. So. Sean, it's -1 in Cleveland. Is Clyde warm enough? Yes. Clyde's all snuggled. Hold on. Let me check. Hey, babe. Is Clyde snuggled up with you? Is he sitting in your lap? Oh. Well, apparently Clyde's sitting there snuggled up with 2.0. So. Is that Bonbon? Come here. Bonbon. Come here, pretty girl. Bonbon. Bonbon. Come here, Bonbon. Yeah, she's not coming, so sorry. Sorry, chat, no Bonbon tonight. No Clyde appearance either. No, because they're sitting there, like, not doing anything. They're just like, it's cold, and they're snuggled up. They're hanging out with 2.0. So, we're done, chat. I didn't stream enough for Clyde to show up. Yeah, well, that's my fault. All right, guys, that's it. If you guys are new, once again, thank you for being here. My name's Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland area. And yeah, celebrating Aaron Spencer's victory. Big one. Big one. So thank you guys all for being here. We are going to go, I paint models for fun. So we're going to go over to my other channel so I don't ruin the algorithm. We're going to go do that. And yeah, thank you guys all for being here. Tomorrow we're going to work in the Brandon Banfield trial. That should be some fun. Apparently it gets a little heated up out there. And tonight we're going to work on our bolt action We're going to work on our bolt action tabletop guys. And what I did schedule. Oh, PM. There we go. And we're going to work on those guys, have some fun. We'll listen to the casino and just work and enjoy it. It's a nice cold Friday night. And yeah, hope you guys join us. And I will direct us over there. So with that said, guys, please remember till next time. Just because you did it does not mean you're guilty. Aaron Spencer, still not guilty. Never going to be guilty. Actually, he's guilty of one thing. He will not be eating a steak dinner with me after he gets acquitted. That's all he's going to be guilty of. That's all he's guilty of, chat. Because what he did was unfathomably based, and society should give him a pat on the back. Maybe sometime they will. With that said, chat, good night. Take care of yourselves. I'll see you guys over on the model bench. And I'll redirect over there.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was. He even knows he's